Okay, well, it's 2 o'clock and we have a few preliminaries, so we're going to go ahead and get started. Good afternoon or good morning, depending upon where you are joining us from today. My name is Karen Booth. I'm a partner at Thompson, Hine, and I'm also the practice group leader of the transportation group at the firm. Joining me today are my Thompson Hine colleagues, partner Sandy Brown and Jason Tutrone, and senior counsel Jeff Marino. We'd like to welcome you to today's webinar. This session will be discussing the proposed merger between Union Pacific and Norfolk Southern and what it means for shippers. I did want to note we will be doing a webinar series regarding the merger, and our second webinar will focus on how to analyze the competitive impacts of this merger, and that's going to be held on August 22nd at 2 p.m. And we'll be sure to get another notice out to everybody attending today regarding that second webinar. Before we begin, just a few housekeeping items. Today's program is being recorded, and we will send a link to you within the next few days. The presentation is intended for the general information of individuals and organizations, and the thoughts and opinions expressed today are those of the individual panel members only, and do not necessarily reflect the opinions of our clients, employers, affiliates, or of the firm. The content should not be taken as legal advice, as the views expressed here are for informational purposes only. Importantly, if you have any questions during the webinar, and we hope you do, feel free to use the question box located in the control panel on the right side of your screen. We will answer as many questions that we can get to at the end of the webinar, and we can certainly follow up on those that we can't get to during the presentation. In the handout panel, you can download a copy of the PowerPoint slides we're going to use today and the bios of the speakers. So again, thank you for your interest and in joining. And again, if you have questions, please use the questions box. All right, so with that, here's what we plan to cover in today's webinar. I'm going to quickly just give some background about the Union Pacific NS transaction. And then we're going to turn to the standard of review for this merger. And that really falls to the STB. Myself and Jason and Jeff are going to tackle that because there's quite a bit involved. There's statutory requirements, STB rules, and certain powers that the board has to condition mergers. And we're going to cover all of that for you today. And then we're going to turn to Sandy. She's going to cover the proposed timeline for the merger review process at the STB, and also help everybody understand what the opportunities are to actually participate in the merger. And then at the end, we're going to get to your questions, and we certainly encourage your participation. So here we go. Background. Just over a week ago, Union Pacific and Norfolk Southern filed a notice of intent with the STB, letting the board know, letting the public know they do plan to file an application with the board to merge. And this notice of intent that gets filed is important because it starts to trigger certain specific statutory and regulatory deadlines for the review of the merger. And specifically, basically, once that NOI gets filed, the applicants will have to put the actual application before the board within 3 to 6 months. It's a very specific window that will apply. And here, of course, the UP will be acquiring the Norfolk Southern and integrating NS into the UP system and creating the very first transcontinental railroad in the United States. The next slide here shows you what the system looks like currently, with the UP obviously in the west in yellow, Norfolk Southern in the east in black. And you can see that it is largely an end-to-end merger here. And of course, the applicants are touting already very strongly, you're going to have this first transcontinental coast-to-coast system. I'm not going to go through all the facts on the right, but just a few key points here. This new system will serve 10 international gateways within Mexico, Canada as well. And again, we'll offer single line service coast to coast. And what the applicants are currently saying is that it will save some customers 24 to 48 hours in transit time. In their notice of intent, they're asserting that customers are going to benefit from faster, more efficient, and more reliable service, and that it will lower costs for the supply chain. Those are all welcome promises. We hope that that will in fact take place, but we also know from experience that there are lots of promises made before the regulators regarding these mergers that may or may not come to fruition. Next slide. Okay, so turning now to the actual approval standards that the STB would apply. Here, the board has exclusive jurisdiction to review this merger between two major Class 1 railroads. The Department of Justice, which we often think of as the regulator over major mergers, has no decision-making authority here. It's exclusively before the STB. That does not preclude DOJ if they want to participate, if they have opinions they want to express about this merger, favorable or unfavorable, or if they want the STB to take certain actions, they have every right to do that just like every other participant. But again, it's all on the STB's shoulders on whether or not to approve this merger. The standard that the board applies is consistent with the public interest. And that, as you can see just from that language, it is a very broad standard. It's not, giving extremely specific details here, but rather what the board has to do is engage in a balancing of many factors to basically evaluate what the impacts are, what the harm may be, and what the benefits are, and do the benefits outweigh potential harms. By statute, the STB must consider certain factors listed here. Adequacy of transportation to the public. Well, that is service. It's all about service, and that's going to be a major issue for sure in this proceeding, as it is in every merger. The effect on other rail carriers. Does it harm other rail carriers? Does it, impact their customers, their operations in any way? I can tell you that BNSF and CSX have already filed notices of intent to participate in this proceeding. Coincidentally, on the same day, maybe not, who knows? And then the third factor the board must consider is resulting fixed charges. That sounds a little ambiguous. What's being referred to there is really what's the total transaction cost? In some cases, might a railroad overpay for another carrier? And how will that affect, the going concern of the entity, its service to its customers? What promises do they make for infrastructure investments? The board will take all of that into account. The impact on rail carrier employees, also a major consideration. I think publicly now we have heard from at least a couple unions who do not think this is a good idea, at least at this point in time, before a lot is known about this transaction. And then lastly, probably very important to many of you on the line today, what's the impact on competition? And that includes rail-to-rail competition, intermodal competition with truck and water, product and geographic competition. So it's a bit of a broad bucket there, but a very important one. And so my last point here is when the carriers file their application, one of the things they will have to do is their own impact analysis on these points. And they have indicated in the notice of intent that the base year they will use for that analysis will be 2023. And so, they'll have to explain that, I think, in the application. So with that, let me turn it over to Jason, who's going to get a little bit more into the weeds of the board's rules.
Thank you, Karen. In 2001, the board updated its merger rules to address how it would analyze the public interest if the industry consolidated any further with transcontinental mergers. So this is going to be the first time that we'll see the board interpreting the public interest standard under these new rules. And these rules came really on the heels of several rail mergers in the 1995 to 2000 period. And some of the concerns that arose from those mergers was that you had significant service disruptions following the mergers. And it seemed very likely to the board at the time that there would be further industry consolidation, resulting in two transcontinental railroads in the United States. And then in 1999, we saw BNSF and CN propose a merger. And so that just really made it very likely and clear to the board that a new round of consolidation was imminent. So the board put a moratorium on mergers so that it could take a look at concerns that the rail network at the time had not yet recovered from the service disruptions of those prior mergers. And they were really concerned about, again, that prospect of that consolidation. So they looked at that at that time, and then they issued these final rules, which essentially applied a heavier burden to show that a merger is in the public interest. And that under that public interest analysis, what the board is looking to see is that there are substantial and demonstrable gains in important public benefits that outweigh the potential harms of the merger. And those harms could be anti-competitive effects and potential service disruptions. Now, a key part of this is that the board in those rules places a much greater emphasis on enhancing competition, saying that it's going to give enhanced competition substantial weight. So when looking at this merger, the board isn't going to be doing what it did in the past, where it looked at whether maybe competition would be reduced. It's going to be looking at to what degree is competition actually improved by this merger, and what degree may there be anti-competitive effects that need to be addressed so that you have more enhancement to competition. And just one further point, this enhancement to competition standard was developed in part because the board recognized that there were inherent risks in a merger of anti-competitive effects and also service disruptions that were not going to be easily remedied through a merger process. So for those reasons, it sought to increase the burden here and see and emphasize the need for those enhancements to competition. So when we think about these considerations as far as what is the board looking at when it's conducting this weighing test, you'll see on this slide sort of two different sets. You have considerations of potential benefits and then potential harms. On the benefit side, improved service and safety is an important benefit that the board is going to be looking to see. We already talked about enhanced competition. There's going to be substantial weight placed on that. Also, the board is going to be looking at, is there a greater economic efficiency? Are the carrier's finances going to be strengthened by this? And are there going to be increased marketing opportunities? On the other side of the ledger, when thinking about harms, reduced competition is going to be a clear harm. If there's essential transportation services, these are services where shippers don't have other options. They rely on rail service. There's no other intermodal or intramodal available or competition available or option available. Is there a harm to those essential transportation services? Is there going to be a lessening of those transportation services? Additionally, the potential for service disruptions. Part of the merger application process involves the service assurance plan. What are the likelihood, based on what the carriers put together, what's the likelihood of service disruptions here, and also looking at their network for potential service disruptions. And then finally, what the board also wants to see is that this merger is going to produce benefits that can't be realized through any other way. So if the board can see that some of these benefits, maybe there's benefits that could be realized through, say, a marketing agreement or some sort of alliance, in that situation, the board might say, well, why don't you engage in that marketing agreement or engage in that alliance rather than do a merger? So where there's an alternate means to produce the benefits, the board is going to favor the alternate means versus the merger. Now, we're just talking about potential harms. There are ways in a merger that the board tries to address those harms. One of those ways is through the use of conditions. I'm going to turn it over to Jeff now to talk about the role of conditions in the STB's merger process.
Thanks, Jason. I think it's safe to say that there's been no major rail merger that was 100% benefits. There are consequences to any rail merger, and it's possible for the STB to look at the skeleton of the merger and say, on net, the consequences outweigh the harms, and therefore the merger should not be approved. However,
Guys, I can't hear Jeff. Can you hear Jeff?
Oh, it looks like we lost Jeff.
Like he's frozen.
Okay. Jason, do you want to run through this slide?
I'll run through conditions until Jeff comes back on.
Rejoins. Yeah.
So, as Jeff was saying, no merger is perfect. There's always some potential for competitive harm. And so the way that the board in the past has addressed that is what we call merger conditions. These are essentially requirements, processes, mechanisms to try to mitigate or offset those harms to the public interest. Now, when looking at conditions, it's going to be looking at it's going to be making sure, it wants to make sure that those conditions are operationally feasible, that they do provide benefits. The objective of a condition is not to impose some sort of unreasonable operating or financial burden on a carrier. It's really to just mitigate or offset those harms. So conditions also are going to come up in the context of enhancing competition. So as I was saying before, there may be some there's inherent likelihood for competitive harms that just are not going to be easily addressed or avoided, and so conditions could be used to create those enhancements to competition. And so let's look at kinds of conditions that we've seen in the past. We've seen conditions that would preserve major existing gateways. So instead of where you may have a merger that would allow the new carrier to take traffic from an existing gateway and maybe route it a different way, and so that might foreclose access to competition through that gateway. We've seen conditions to preserve those gateways. A big one is 2-to-1 shipper protection. So this is where a shipper had, before the merger, access to 2 rail carriers serving its facility. And maybe it's serving the origin or serving the destination. And then because of the merger, those 2 rail carriers combined, so now there's only access to one carrier. So in those situations, the board has imposed certain protections, such as reciprocal switching. Additionally, to address that, you've also seen what we call trackage rights, which would allow a carrier to operate over the tracks of another carrier to serve shippers off that other carrier's line. So a situation like that that we saw at trackage rights is the UP-SP merger in the area of, say, Lake Charles, Louisiana, really along the Gulf Coast. We saw BNSF obtain trackage rights so that they could operate in part on the UP's line to serve some traffic that lost some competition. There's been what we call limited bottleneck relief. so railroads have the right to carry traffic as far as possible along their line. And so when you have a situation where you have two carriers merge, especially when you have maybe an end-to-end type of scenario like we see here, now you might see, say, someone originated traffic on NS. They had the opportunity to interchange at a gateway to either BNSF or UP. Well, in the future, if this merger goes through, that interchange is not going to happen. It's just going to go NSUP all the way. So that bottleneck at the beginning where there was captivity is going to extend through the entire length of haul or most of the length of haul. In that situation, you may see some we call limited bottleneck relief where where the carrier or the shipper has some ability to obtain some competition based on that loss of that extension of the bottleneck. Additionally, one thing to keep in mind is that conditions aren't something that the board necessarily has to impose, or they don't just come from the board. Let's put it that way. They could result from voluntary agreements. So when we've seen that, UPSP and other mergers, railroads volunteered certain merger conditions. You had volunteering of reciprocal switching and other types of conditions in those mergers. But again, the statute does give the board authority to order certain conditions, such as divestiture of tracks. This is where maybe that divestiture would enhance competition by bringing another carrier in or near the new merged carriers network. We talked about this before, granting of trackage rights and also access to other facilities.
So Jeff made it back. Thank you, Jason, for covering that. And Jeff, sorry, technical difficulties, everyone. Jeff, just want to give you a chance. You've had a lot of experience in mergers. If you had any other comments around the conditioning powers of the board.
I think I'll reserve that for Q&A. I noticed there are several questions about that online, and I'll tackle that at that point.
Okay, great. Thank you.
Well, thanks, Jeff and Jason. I mean, the conditions that, will be imposed or could be imposed by the STB on a merger transaction are going to be very important, especially as we dig into the benefits and harms, from this potential transaction. I will still call it a potential transaction because, when these new rules came out in 2001, I actually was working for the railroad side, and I did not expect that 24 years later we would be talking about a transcontinental merger when it was very clear, at least back in 2001, that the STB did not want that to happen. But it is a totally new world, and I haven't worked with railroads since 2003. So, lots of things can change. But I'm going to say that a million times probably, UPNS has proposed a lot of benefits that they're claiming in their media investor materials that this transaction will bring. Some of them, may actually be benefits that could happen from the transaction. I think one that you're seeing in the questions and that many people are concerned about is service, both in the short term and in the long term. And will service, actually be better? You can see here from this slide that they talk about, some of those and benefits from enhanced competition and benefits to customers are about faster connections, more connections, faster transit times, increased reliability. And I think as Jason mentioned earlier, reliability has not exactly been a word I would associate with post-merger, integration. So one thing that is very new that came out of the 2001 new rules is that they will have to, the applicants will have to include in their merger application a service assurance plan. And the service assurance plan will have to be prepared in connection with the operating agreement. And the rules say they must identify precise steps to ensure projected service levels. So, there hasn't been a merger that's been under these rules, so we haven't seen what that service plan will be. But if you look at what the STB says in the regulations, there's supposed to be a lot of detail, including information about if you don't meet the metrics that you plan, what should be the additional conditions that might impose. So I think that's going to be a really key piece, to watch for and to be thinking about in the context of your business. Next slide, Jason. So let's talk quickly about the timeline that the applicants have proposed. They have a timeline that they proposed in the materials that they filed with their pre-filing notification. They did that on July 30th. And so the application then by regulations can happen within as soon as 3 months or as long as 6 months. The pre-filing notification has to be filed at, within that time period. So we've put here sort of what we think could be the earliest time period versus the latest time period, for them to actually file the application. And there will be, various then stages that follow from that based upon provisions that are in the statute for timing. But you can see here that could potentially have an STB decision by the end of 2026 or by first quarter 2027. So we're not talking about a really long distance time period of when this could happen, and of course what happens with the next major mergers as well. Next slide. So I put on this next slide just real quickly, just so you are aware, the STB has a sample timeline on their website that you can look at, and the link is there. Those dates are roughly the dates in the box next to it here. It essentially adds about a little over 3 months longer than what UPNS is proposing for the timeline. And those are statutory timelines. Now, I say that because the timelines are in there in the statute that say the STB shall do these things by X date. But the STB also has some ability to change those dates by moratorium, which is something they've done in the past, or other ways to ask for more information. But that will be something that I think the railroads will be pushing to say, when we file the application, it triggers a certain time frame that you have to make a decision about this particular proposal. And the reason why I think that's important is when you go to the next slide and you look at UP's 8K that they filed, there is an end date in the merger transaction document that is available on the SEC filings. And that end date shows of January 28th, 2028. Now, it can be automatically extended under certain circumstances, which UP acknowledges could be, for example, that the STB extends the time period to seek additional information, or that certain regulatory or statutory deadlines are suspended, told, extended for any reason. But absent those sort of things, if UP does not obtain regulatory authority by January 28th, 2028, UP would be responsible for paying a $2.5 billion termination fee to Norfolk Southern for not obtaining regulatory authority for the transaction. Likewise, there's a mutual termination fee in the documents of $2.5 billion for either side if their individual board of directors recommends basically against the transaction and doesn't vote for it, or if there's, quote, an alternative business combination transaction that subsequently occurs. So if another railroad came in and attempted to acquire Norfolk Southern, UP could be on the hook for Norfolk Southern accepted that other offer, they could be on the hook for a $2.5 billion termination fee that they would have to pay to Union Pacific to get out of this transaction. So there's a lot at stake when you're looking at that transaction. So key opportunities for participation that, it's been mentioned. The schedule that's out there, there is an opportunity to comment on that schedule, to ask for more time, to ask for, additional time to be put into the overall schedule. And then even prior to the application be filing, settlements can be negotiated. Sometimes entities will try to negotiate and get conditions, or the railroads will try to negotiate with shippers to get their support for the application and for the process. The formal STB process will have an opportunity for parties to file comments and request conditions, to seek discovery, and to otherwise participate in that process. And then even after the application is filed and throughout that formal process, there can be additional opportunities to negotiate according to conditions or items that you feel are necessary to protect your particular business from the transaction.
Okay, great. Thank you, Sandy. So this is our last slide, but it's quite an interesting one, and I'll cover this one. Of course, this is the current makeup of the STB. We've got 4 sitting board members, but it's a 5-member board, so we have an open seat. You've got Chairman Patrick Fuchs, he's a Republican. You've got Robert Primus, who's a Democrat, Michelle Schultz, who's a Republican, and Karen, who's a Democrat. So you've got a 2-2 R to D current makeup of the board. I mean, I'd say generally speaking, freight rail has not been overly political, but I would think if you're the applicants, this might make you a little bit nervous, right? Because if let's just say the whole transaction went through and you know, potentially these 4 were to stay on the board with some additional nominations, just the 4, that creates a risk of a 2-2 split. And in such a case, the transaction would not go forward. So what that means is this open seat becomes very important to break that potential 2-2 split possibility. And getting 5 on the board creates a greater likelihood that if there was to be dissension over whether to approve this merger, you would have more of a 3-2 possibility. That open seat will be a Republican seat because we have a current Republican administration. There is some chatter out there about a couple of candidates who are under consideration, but there has been no formal nomination yet, and that 5th person will have to be confirmed by the Senate. But we put the terms up here of the different board members who are currently sitting on the board because it creates a little bit of a puzzle and an interesting dynamic. If you start with Karen Headland's term, you see here that her term actually expires at the end of this year. But what is very common is if you're not renominated immediately, usually there's a 1-year holdover where that board member whose term actually expired can remain on the board and continue to function as a full board member until they're renominated or not. And so there's a question mark here because thinking about the dates that Sandy went through for you, the holdover year for Karen would obviously expire at the end of December 2025. I'm sorry, 2026. That would only allow her to be there for that 3-month period if the applicant's schedule was accepted on the shortest time frame. So that's an open issue. And then, of course, you can look at Michelle Schultz's term. She also expires January 26. If she stayed on for a holdover year, she'd go to January 27, but that 6-month time period decision date was February 27. So she could potentially fall out of the mix here. So basically, we've got a very interesting dynamic going on, and I would say this is something we and many folks in the Washington circles will be following this very closely. And it's a bit hard to say, you know, Washington, whether there'll be political shenanigans around who to influence to fill that 5th seat. We'll keep you all apprised of that. But we did want to point this out to you because this is, you know, just creates some interesting dynamics here. So with that, that was the end of our formal presentation. We want to now turn to questions. And I think we do have several of those. And maybe Jeff, we'll turn to you to kick us off.
Sure, thanks, Karen. The first question is when CN tried to merge with KCS, they pulled the plug after the STB would not consider that merger under the pre-2001 old rules. And CN clearly saw no path forward to approval under the new rules, so has anything changed that makes UP think they will have better luck? Several things may be different, including how CN and UP would look at such a merger. CN KCS merger would not be entirely end-to-end. There was a significant amount of overlap, but it is probably less a factor that CN saw no path to approval, but more that CN saw the potential conditions to approval being such that they would not be acceptable to CN under the circumstances. Another major change, however, is we have a change in administration here in Washington, D.C. And we actually see UP playing to that change in its media blitz on this merger by referring to this as the one big, beautiful railroad. And there may be a sense that there's more receptivity in this administration to such consolidations than there may have been in the prior administration.
Karen, I'm going to jump forward to another question ahead that's sort of implicated by that one is the question was raised, did the CP-KCS merger fall under the 2001 merger requirements? And KCS received an exception to the new merger rules. And so although, as Jeff mentioned, the CN-KCS was not going to be ruled on because there was so much overlap, the CP-KCS merger was under the old rules. So even though that happened more recently, the old rules applied to that merger. So this would be the first merger to fully be evaluated under the new merger rules. New 24-year-old merger rules.
There's another question I'd like to tackle here, and that has to deal with service disruptions, because I know that's on the top of a lot of people's mind. And the question is, when the STB lists service disruptions as a determinant to a merger, are they looking short-term or long-term? Because there's almost 100% guarantee that there will be service issues in the beginning, as we've even seen with the CP-KCS merger, despite their grand promises. The STB actually tackled that question in adopting the 2001 new merger rules, where many of the railroads had challenged the consideration of service disruptions, noting that any service disruption would be transitory. Ultimately, it would end, and therefore it should not be considered at all in an STB merger. The STB's response to that at the time was that when the railroads calculate the net benefits of their merger, the valuation of that is on a net present value basis and assumes no service disruptions. So when there are service disruptions that affect shippers and the rail networks that may last a year or more, that may set back those benefits by several years, and therefore that may impact the balancing of the net positives and negatives. Now, that's easy to say and express in the STB's term, but what does that mean the STB will do? And we've yet to actually see this, other than in the requirement that the railroads prepare service assurance plans in the nature of these mergers. It's a little unclear how the STB can really condition a merger on service that is going to occur in the future, or service disruptions that may or may not occur into the future.
Yeah, Jeff, and I would say there's a question somewhat related, just because, but real life examples, right? There's a question here related to whether the challenges that CP-KCS, that combined entity, is having currently, will that have any impact on how the board evaluates this merger and the service challenges? And, you know, I would say yes. I think the board has been hearing quite a bit about those problems, and it's pretty raw, I would say, still for many shippers who will continue to be affected by those challenges. I wouldn't say that it would rise to the level where it would lead to a disapproval by any stretch. It comes back to the conditioning powers of the board and whether or not what Jeff just mentioned, this obligation of the applicants to create a service assurance plan, is that enough? And I think we mentioned to you all, and Sandy, it was what you covered, in opportunities to participate. It's really incumbent on shippers and their representatives through their trade associations to raise these issues directly at the board, to say there needs to be more accountability. It's great to have a plan that you will put in place for service challenges, but the reality is the plan that they develop today, before the service problems happen 2 years or 3 years down the road when they integrate systems, is a big disconnect. Now, those plans, of course, are intended to also be developed in response to the problem. But I know when I talk to my clients and shippers, there's a big frustration that there's not a lot of accountability other than maybe some public embarrassment. And yet the shipper has to deal with the disruption to the supply chain, the lost cars, the customers who are unhappy, having to move to truck at higher expense. And the issue is, can the board do more in its conditioning powers around service, given that we know the applicants are going to come in and promise the moon, as did UPSP, as did when the Conrail breakup happened, that, oh, it won't be us, we'll do it better. They had problems, and then CPKC came in and said, we won't have problems on integration, and yet everyone has. So I think this will be something the board will pay attention to, and shippers need to think about what could have been done better, what other conditions might there be, and ask for those from the STB.
Yeah, Karen, there's a question in the question box that touches on this a little bit, and it says, what would the STB propose the release or sale of some tracks to assist with competition, making this a stipulation of the merger? And then further, what are the chances of reciprocal switching becoming being imposed more similar to what exists in Canada? So, I mean, those are two parts of a question that are really great questions. The STB statute does specifically note divestiture as a potential condition. To date, the STB has never granted divestiture, but it's a brave new world. It's a good question. I mean, usually divestiture is more where you have parallel tracks, and because, as I think Karen mentioned at the beginning, when you see the picture of the two, there's not a lot of overlap, but it definitely is within their power to order divestiture. The question is whether they're willing to, and I do think that it has to be specifically, requested. So Karen, Jeff, or Jason, if you guys want to talk about reciprocal switching, I know we all love that topic.
Yeah, I think this also dovetails with another question about whether UP's position in the CPKCS merger might how that would affect some of the competitive issues here. And I think that relates specifically to reciprocal switching. The STB in the pre-2001 did not consider extended bottlenecks to be anti-competitive as a matter of default in a merger proceeding. And in the CPKC merger, in large part due to the testimony of UP's own economic witness in that case, the STB backed away and said that economic thinking had evolved in the last 20 years and that there are competitive harms simply from extending the length of captivity, the bottleneck segment, for any shipper facility. As a result, this is an end-to-end merger. And most of the anti-competitive effects are not going to be from parallel lines. They're going to be from extended bottlenecks. For example, a shipper who might be captive to UP today, but ships to the East Coast may have the option of connecting with either CSX or Norfolk Southern today. After this merger, UP would be able to direct that traffic on its single line route with the new UP-NS routing, removing CSX from the competitive picture in that situation. Reciprocal switching is one potential condition that could mitigate that harm and still preserve the alternative option of using CSX. And because the new rules also state that enhanced competition may be necessary, reciprocal switching at the origin may in fact allow BNSF to handle the traffic competitively all the way to the East Coast before interchanging with CSX, thereby giving competition even west of the Mississippi River in addition to east of the Mississippi River. So I think all of this is in play, and it remains to be seen exactly how strenuously the STB is going to interpret this enhanced competition standard.
And I would just make one point with respect to reciprocal switching. Reciprocal switching is really something that is for relief or access around a terminal. So if you are more distant, if you're not really within close proximity to a terminal, to an area where there's an interchange with a competitor, then what you want to be considering is how do I address this long bottleneck in another way? Are there maybe dispute resolution processes or other mechanisms that can that can be put in place to address the UPNS's ability to assess assess its rates or set its rates at reasonable levels.
Yeah, we might have time for one more question or a couple more. I'm not sure, but there's one in here I think would be really good for this group to talk about. The synergies noted in the merger are largely based on a significant amount of truck conversion. How do we as carload shippers approach addressing concerns about subsidizing intermodal business? I mean, it is true. Their materials really tout the benefits to intermodal service and competition with truck, because they can't claim competition with railroads. So
yeah, I mean, Sandy, I think it is a great question. And I think I mentioned earlier on, obviously competition being a major factor that the board needs to evaluate, it will evaluate it broadly. So intermodal competition, and intermodal service, in competition with trucks will be something the board evaluates and assesses, but it won't be the only aspect. And I think it's really the captive shippers who have one service provider and will face these extended bottlenecks, as Jeff described. You're going to need your representation here because you need to counter these benefits that the applicants will tout. They will have their experts, they'll have all kinds of verified statements, they'll quantify it. But the board needs to hear from the carload folks and even unit train folks who are not intermodal and who may actually see these extended bottlenecks and need some sort of conditioning powers put in place by the board to address it. So I think that is a really good question. There's no doubt they are going to focus very heavily on that, and there needs to be a little bit of a balance to make sure that captive shippers' voices are heard.
Yeah, I mean, I also think there are things, other harms that can come from, having fewer carriers out there. Something which seems like outside of the STB, and obviously contracts are outside of the STB, but a lot of times they incorporate tariff provisions. And when you have only really 4, major railroads in the US, they all have similar but sometimes different provisions. And when you merge two, do they take the worst provisions of both and combine them now and essentially then capture a larger portion of the shipping community under very high indemnity clauses, very high insurance provisions, all of those sort of provisions that we, regularly see as issues? And does that become even a broader problem than, the particular carriers that currently have those provisions?
Yeah, that's something. Sorry, Jeff.
Oh, I was going to say that there was one other question that I wanted to make sure we got answered here before too many people have to drop off, and that was, are shippers able to request conditions during the comment period? And the answer to that is absolutely. That is designed into the schedule by the STB as your opportunity to request conditions. And you can do so, either conditions can be broad or they can be very specific to an individual shipper facility.
Jason, did you want to address one more, and then we'll probably do a wrap?
I was just going to just talk about what Sandy was discussing about how carriers may take a tariff that is more onerous and then apply it to the acquired carrier. And we did see that in the CPKC merger. So that was different rules. Again, how is the board going to apply its current rules to this particular merger? This is a novel application of those rules. But but that definitely is something to be thinking about. And of course, as Jeff was saying, your opportunity to address that is going to be during this comment period.
Okay, well, we have had a lot of great questions here. We strongly want to thank you for participating today. We appreciate that very much. As I mentioned at the outset, we will be doing a webinar series about this transaction. Our next webinar is going to be on August 26th at 2 p.m. and it's going to focus on the competitive impacts of this proposed transaction, potential conditions to mitigate competitive harms. We started to touch on these topics today a little bit in the Q&A, but we will plan to do a much deeper dive in that next webinar. So please join us for that. Keep an eye out for an invitation. And we want to thank you very much for participating today. And with that, we will wish you all a great end of the day and a weekend, and I hope to be in touch with you soon. Thank you.